Thank you very much for the invitation to participate. It's a great pleasure to be here with so many expert voices. I wanted to start by first disclosing that I do expert witness work. In particular, just now I'm working for Amazon on an antitrust matter. On the DMA in general, I think it's a really great first step. There is a lot to like here. I think in particular, what I appreciate about the DMA is that it's reacting to the last 10 years of antitrust enforcement, both in the EU and the US, where we learned that this just was not enough. I'm a big fan of antitrust. I think it's necessary and valuable as an area of enforcement. But in the EU, there's been 10 years of cases against Google and no change in market structure. In the US, we had absolutely nothing going on until 3 months ago, when suddenly the dam broke and there's a flood of cases. But those cases will take 6 or 7 years to resolve by the time we have all the appeals. And I think there's just a hunger to move faster than that. And certainly digital and technology markets move faster than that. So in addition to antitrust not being quick enough, I also think there's a really important kind of business model that is captured by the DMA that's not captured by antitrust enforcement, which is the business that was lucky, that got network effects on its side at the right moment. And because of the network effects and economies of scale, gathered tremendous market power. And now has an entrenched position and is taking all the surplus. And we don't think that there's an efficiency reason why that should be the case, and that area would benefit consumers more if it were subject to competition. So this is where we get the fairness piece. Why is that lucky platform extracting all the surplus? And we get the competition piece. What we'd really like is to have more contestable markets in the sense of lower barriers to entry, so there can be more entry, more competition, and more choices for consumers and businesses both. What do I see these regulations doing? I think, as Ingrid said, gatekeepers are defined very simply by size and have they been there for 3 years. And this is completely rigid and probably a good choice in that it saves years of litigation. It's certainly fast. It certainly creates legal certainty. But I think that then, in combination with rules that have no flexibility, you're setting yourself up possibly for the sort of clash that Henrik was speaking about. I think that there's an infinite variety of strategies, of kinds of markets, of products, of consumer behavior, and these things will never be neat. And if you set up a system where there's just no escape hatch when the situation doesn't match what the rules envisioned, then inevitably there will be a clash down the line and some kind of unintended consequence or some kind of business that consumers would like to use and cannot because of these rules. So I do think it's worth thinking carefully about a kind of evaluation that would be sufficiently strict, put burdens on the firm to explain what was good, have as a goal both of these factors, fairness and contestability, but would allow companies to make sure that they're being constrained by rules that are intended for them to be constrained by and not rules that are accidentally constraining them. The most exciting part about the DMA to me are the parts that are more general. A lot of these rules seem to be taken from past cases, like we can identify Spotify and we can identify Google in the set of conduct, but just those names have been taken out and they've been generalized. And I wrote a little piece with Christina Cafara in Vox about kind of trying to re-identify all the rules. And those, I think, are the ones probably most likely to be problematic. But the ones that are exciting to me are the general ones that talk about portability and interoperability. I think this is a really exciting area to make real progress in lowering entry barriers. If markets are interoperable, if the platform and all the products are interoperable, that means that they hook up to each other. That means that there aren't switching costs for consumers. That means that economies of scale and network effects occur at the market level. And that makes it very exciting for a new entrant because they can enter and get business if consumers are attracted to their product. So this is a really excellent way to go. It doesn't require a heavy lift in the sense that What's needed is a common standard for interoperability, and then the market takes care of itself. Firms enter where they want to, consumers move their business around with no friction, and we have big network effects. So I think interoperability on a kind of moment-by-moment basis, and portability, where a consumer can take her data from one place and bring it to another, also promotes entry and promotes competition. So these are two big areas that I think are really exciting. And then a third one, which is throughout the rules, is really a broader view of consumer protection. Like consumer protection includes small businesses. There should be transparency about lots of things. We should be told how ad markets are working. We should be given control over our data. Firms should be prohibited from merging different kinds of data that consumers don't want merged. And if you look at all of those provisions in the DMA, there are really quite a few. And I would characterize that as a kind of a more robust, digitally enabled consumer protection agenda. And I think that's really healthy and good, and stands to make these markets more fair, because people will understand what's happening to them, and so will businesses, and more contestable in the sense of lowering barriers to entry, where an entrant might be offering better quality or a different way to do something that's less invasive in terms of privacy, and consumers might want that. And if they understand what's being offered and they have control, then they are able to choose it. So I think these are great directions. I think there's some adjustments that could be made to make it a more effective law that protects consumers but also enables productivity and efficiency. But in general, we're headed in a great direction. Thank you.